morning, dear faculty members, researchers, and students. Let me have a privilege to welcome you all in IPR Awareness Program. Intellectual property rights, IPR, have been defined as ideas, inventions, and creative expressions based on which there is a public willingness to bestow the status of property. IPR provides certain exclusive rights to the inventors or creators of that property. In order to spread awareness among inventors, the Intellectual Property Rights Day being celebrated every year on 26th of April. And we are glad to inform you that the Institute Innovation Council, Department of Zoology, and PG Department of Commerce and Management of GGDST College, in collaboration with the Ministry of Commerce and Industry, GPIIT, Intellectual Property India under NIPAM, NIPAM, have organized an expert talk on IPR awareness program. The aim of this program is to give an exposure to different types of intellectual property rights. Additionally, it aims to enlighten and motivate students to convert their ideas into innovation and further transform them into IP assets through protection of their IP rights. Now let's proceed further, and I would like to invite the principal of GGDST College and president of IIC, Honorable Dr. Ajay Sharma, to grace us with your insightful words.
Respected Nikhil Ranjan ji, examiner of patent design, NIPAM officer at Kolkata, dear faculty member and dear students. Firstly, I would like to welcome our speaker, Nikhil ji, and thank all of you for joining today on the World Intellectual Property Day. Last decade has actually created a lot of opportunities in India, particularly for IPR related issues. Not only filing of patents and copyrights, trademarks are increasing. This is creating new opportunities for all the startups also, the person from legal professions also. And such type of awareness sessions are actually helping us to understand the intricacy. Hopefully all of us who have joined today for having awareness session on intellectual property rights not only will be aware of the basic things but also be in a position to understand that how they can actually file the patents, copyrights and other things. For teachers now the trends are increasing but challenges are still there. Applying a patent is different from the publication of patent, and the patent in India may be different from the patent from other countries. Number of times we are having such challenges while teachers are talking about that I am having a patent and we are saying it's only application of patent, and application of patent is different from the granting of patents, and such confusions are there because of lack of clarity. Hopefully with the presence of Nikhil ji today we will be in a position to clear a lot of doubts which we are having. So welcome to the ST College. College is having NAAC A+ status from National Accreditation Council Bangalore, having CP College of Consumer Excellence status from UGC. We are also recognized by DBT and DST for the science programs as a star college. We are also ranked in NIRF, National Institute Ranking Framework. And these days our focus is on the research and on the IPRs also. So welcome again to the college. Thank you.
Thank you, Principal Sir, for this formal welcome and enlightening us with your words of wisdom. Now, I would like to invite my co-host, Dr. Meenu Gupta, Assistant Professor from Department of Commerce and Management, to introduce our respected guest of this event, Mr. Nikhil Ranjan. Over to you, ma'am.
Thank you, Dr. Gurjeet. Good afternoon to all of you present here. Dr. Ajay Sharma, Principal of the College, Dr. Nikhil Ranjan, NIPAM Officer, Dr. Indu Mehta, Convener of the event, Dr. Vikram Sagar, RIC Coordinator, Dr. Jyoti Joshi, Innovation Investor, and all the teachers from different disciplines and dear students. Welcome you all for this interactive session on Innovation Awareness Program. It gives me immense pleasure to introduce the eminent speaker of the day, Mr. Nikhil Ranjan. He did his Bachelor of Technology in Electrical Engineering from National Institute of Technology, Hamirpur in the year 2017. 6, 2019, he is working as an examiner of patents and design, the Patent Office, Kolkata, DPIIT, Ministry of Commerce, Government of India. Mr. Nikhil Ranjan has vast experience in the area of patents and design, and we are hopeful, sir, that all the students and teachers present here will gain maximum advantage of this talk. With these words, I would like to invite the star of the day, Mr. Nikhil, to please commence his talk. Thank you.
And I would like to mention here for the participants who are having any kind of query regarding IPR, they can ask at the end of this expert talk. Thank you.
We are going to start the presentation on the today topic, that is intellectual property rights. So it is very important to understand what are intellectual property, and then we can understand what are intellectual property rights. Okay. So we know there are two types of properties. One is called tangible property and another is called intangible properties. Tangible property are those properties which we can touch, like gold, ornaments, house, any valuable items that we can touch them. We know how to protect them. We know how to protect the house. We know how to protect our ornaments. We know how to protect our valuable items. And another is called intangible items. Those items which cannot be touched, but they are also very valuable. And they are created by the human minds. What are these? These are called invention, like poems, like story writing. Now the question arises here, how can we protect these items? Okay, we can protect our money, ornaments, we know how to protect them, but how to protect our invention, how to protect our us, how to protect our poem that I have written? What are the rights that are given to us so that we can protect them? And these are the things that we are going to study. Yeah, how to protect those things which are created by our minds. So what is intellectual property? Intellectual property refers to the creation of the mind, such as invention, literary and artistic work, design, symbols, any types of images that we use in the commerce. These all things are called intellectual properties. Why? Because these are created by the minds of the people. These are created by the intellectuals. And those rights which are given to us to protect this intellectual property are called intellectual property rights. The first intellectual means that possesses the mental capacity of a human beings. Property is all the items that is owned by a human beings. And rights are the intangible that is given to us so that we can protect our property. All these things all these things commonly called the intellectual property rights. So, what are the different types of intellectual property rights? First is called patent, then design, then trademark, then geographical indication, then copyright, then semiconductor integrated circuit. For different types of intellectual property, we have different intellectual property. Unmuted.
Sorry for this interruption. Ms. Shilpa, kindly switch off your mic.
Thank you. So we are given different types of intellectual property rights for different intellectual property. Okay. Now you can think like if I have invented something, for that we are given a patent. Okay. I have designed something like a different design of clothes, sari, jeans, ornaments. That for that we are given the design rights. Trademark. Trademark right is given so that we can protect our brand. The brand KFC, brand Pizza Hut, these are the brand's name and these are protected by the trademark. Geographical indication doesn't deal with a particular person. It deals with like a place, like we say the Bengali Rasgulla. It is geographical indication. Copyright is given for literary work. Like someone is writing a book, someone is writing a poem, someone is writing a story, someone is making a movie. All these things are taken under the copyrights. And last one is called semiconductor integrated circuit layout design. So we see the different type of semiconductor integrated circuit that are used in a mobile, in television, in a washing machine, in AC, everywhere. We use the semiconductor integrated circuit. So we have given a separate intellectual property right for this SICLE, it is called semiconductor integrated circuit layout design. We will discuss in detail one by one. So what are the importance of intellectual property rights? The question arises, why there is a need of intellectual property rights? So first important thing is that it is for the protection. Like if you have made something, if you have invented something, if you have written something, it is important to protect them. Second is called commercialization. Like if I invented a washing machine, I want to sell that washing machine into the market. And how can I protect my my invention so that no any other person can steal that? And that is the importance of intellectual property rights. If that right is given to me, no any other person without my permission can use that technology. That is the importance of the intellectual property rights. In IP is an essential business asset in the knowledge economy. Okay, in the economy of knowledge, it is an important business asset. So we will see example, a different type of intellectual property is used in a single product. If you are seeing one mobile, okay, like if you see in the past, some mobile come with two camera, but after some month it comes with three camera. What does it show? It shows technological advancement. There's a new technology coming into this mobile. That what we see when we go to the shop to buy a new product. What new technological advancement has come into a new mobile so that I can buy a new mobile. So if any mobile comes with a two camera, but now some other mobile comes with three camera, that is called technological advancement. And for the technological advancement, we are given the right that is called the patent right. Okay. Now, if you are buying a mobile of a different company, like iPhone, Apple company, Samsung, uh, like Samsung, Apple, in the past there is Nokia, also Oppo. So these all are the different company. But how can, let's suppose I want to sell my mobile in the market. I can't sell my product into the market with the name of Apple. Why? Because that name is trademark of that company, iPhone company. So no any other person, no any other different company can sell their product into the market with the same name. So the brand name is used to differentiate different company, and that is come under trademark. Trademark is used to protect a brand name. In copyright, when you buy any product like mobile, television, they always come with a manual. What does this manual tell us? How to use this mobile, how to use this television, and that is copyright protected. No any other company can copy that manual from that Samsung company because it is copyright protected. See in the patent design, you see the different design of a mobile. Some it's very slim, some it's very bigger screen, some it's a smaller screen. In some past time we see the Samsung come with a foldable mobile. What does it say? It is a design. It also gets protected. Like if Samsung comes with a foldable matter, it is also protected. No any other company can copy the same design as the Samsung company. They can modify it, but they cannot use the same design because it is protected under design. And last one is called SICLD, Semiconductor Integrated Circuit Layout Design. When we open any mobile or any television,
से मैंने बाहर निकाला ना तो उसको दिख गया वो रोज ट्यूशन में आ जाती है
okay. So if we are using any mobile or any television, when we open it, we see a integrated circuit layout, and that is protected under the SICLD. So you see, we are going into the first one that is called patent. We will see the details. What is patent? How to file a patent? How can we protect our product or process under the patent? So what is a patent? A patent is a statutory right for an invention. It is granted for a limited period of time to the patentee by the government in exchange of full disclosure of an invention for excluding other from making, using, selling, importing a patented product or process. So the question is that, there's four important aspects of patent. First is that it is given for the limited period of time. It is not given for a lifetime. So if you are applying for the patent, it is given for the limit time. In India, it is given for the 20 years of time. Now the question arises, why for 20 years of time? Because we know that technology advances. After 3 to 4 years, new technology comes into the market. So after 20 years, that technology will not present in the market. The second one is that the patent is a right that it gives monopoly. Like if any company is making any product and it gets patent, it is a monopoly for the company. So if any company gets the monopoly, they can decide the price. You understand? If any company comes with a phone with only 6G, they can make any price, very high price. But if there are 3, 4, 5 companies into the market which can give us the 6G, there is a price war, and so the price will decrease. So the patent gives you monopoly. So after every 20 years, it gives relaxation that okay, now the different company can copy that technology so that that product or that process can reach to the different parts of the country because there are more poorer people in the country than richer people. So so the poorer people also deserve the technology. So after 20 years, when the technology become old, so different company can use the technology, make the product, and can sell the product into the different parts of the world at a very small price. So you see, the patent is given for the limited period of time. It is given for 20 years in India. Second one is that one who wants to get patent, they have to disclose everything to the government of India. It is not like that you want to hide something and then you can get patent. No, you will get patent only for that technology that you have disclosed. You can't hide your technology. Why it is given? It is given so that no any other person without your permission can use that product, can sell that product, can import or export that product. So if Samsung is making any mobile and selling into the market with a technology called 3 camera, so without the permission of Samsung or any other company like Apple or any other company can use the same technology, and that is the importance of the patent. The last is patent is territorial and exclusive right. What does it mean? It means that if you are applying patent in India, you will get patent only in India. You can't get patent in USA or England or anywhere. For that, you have to apply patent in different parts of the world, one by one. Now, the question arises: that can that person in the US can they use that product without your permission? Yes, they can use that product, but they cannot get patent. You understand? Because if you have filed a patent, it comes into the public. You get the patent in India, it is in the public. Now, if any person sitting in the US wants to copy that technology and want to get patent, it is not possible because that technology in the public, so that person cannot get the patent, but that person can use that product without your permission. So to protect your product, you have to apply patent in all the country one by one. But there is a process. There is a process that is provided through which you can get patent in all over the world by single application. Okay, that we will. That is a very advanced study. We are in the basic only. So in the basic, you should understand that the patent is given only for the limited time, that is for 20 years. Patent is given is territorial in nature. It means that if you get patent in India, it is applicable only in India. Even the person sitting in Nepal can use that product without a permission. And third one is that you have to disclose everything about an invention to the government of India. You cannot hide anything. So term of patent is 20 years from the date of filing of application in India or international filing date. So what are the famous inventions? You see that the aeroplane, tennis swing, telephone, phonograph, these all are the inventors and these all are the scientists. How do we know that they are the scientists? Because they had applied for that product. They had applied for patent for that product. So you see that is the importance of the intellectual property rights. If any X person had invented something, and they get patent for a lifetime, that product will be identified by the person. Whenever we see the airplane, whenever we listen about airplane, we must think about the Wright brothers. These are the people who first invented airplane. Same for the telephone, same for the television, everything, and that is the importance of the patent. These are the famous inventions. Like you see, the one is the anti-gravity illusion that is created by the Michael Jackson dance. It is not anti-gravity illusion. It is a type of shoe that has created an anti-gravity illusion, and that shoe has also got the patent. So one famous example that we see today from the cricket, that is called the.
Hello? Anji, क्या?
So one example that we see is the bill. In the past, about 8 to 10 years ago, the bell doesn't come with a light. So it created some type of error in like runout or stumping. But after that LED stump and LED bell, it decreases the error and it increases the accuracy by which we can decide the correct stumping and correct runout, because we know that light travels the fastest. So whenever the ball hit on the stump, the light comes out. So it decreases the error and it increases the accuracy. And that is a very famous invention. And that inventor is from Australia, and he got a patent for the stump and the bell. So what is the importance is that he can decide the price. You see, that person has invented that LED stump, and by sitting at home, he is earning money because he sold that stump to the ICC. ICC is using this stump in every match, and for every match, that person is getting money. And that is the importance of patent. Like you have invented some technology that can be used in the washing machine. You understand? But you are not the businessman. You cannot sell that technology into the market. So what will you do?
I request all the participants kindly keep your mic off while listening to this expert talk. Thank you so much.
Thank you, ma'am. So you see, like if you have invented some technology that can be used in a washing machine, let's suppose, but you are not a businessman, you cannot you cannot go into the market and start selling the washing machine. You cannot do. But what you can do that you can sell your invention, you can sell your technology to any washing machine company like Samsung or any other company. And for that, you can say that, okay, for every one washing machine you are selling to the market, I want 10% or 20% commission. So if that company is selling like 1 crore or 1 lakh product into the market, you are getting 5 to 10% commission for each washing machine selling to the market. And you are earning this money by simply sitting at home. And that is the importance of patent. Once you get the right of any invention, of any technological advancement, you can commercialize that, you can earn money. These are famous Indian inventions, like a small USB, hepatitis B vaccine. These are important. So like I am also an engineer from engineering college, and we see that in engineering college we write some research paper. But what we do, we write research paper and publish it in some IEEE or any other famous research organization. But once you write a research paper and once you publish it, it comes into the public domain. Now you cannot go to any office and you want any patent for that research paper, you cannot get it because you have already made that research paper into the public. So if you are writing any research paper and you think that this is very unique research paper, it has not been copied from anywhere, and that research paper can be used, can be commercialized, first you should apply for the patent to the Govt of India, and after that you can publish it into any research paper. And in this field we are lagging. We see that the most of the patents have been filed by the US, Europe, China. India is slowly starting now filing more number of patents mainly from the engineering colleges. because there is lack of awareness, and that is our main motto, so that we can create awareness among the people that if you are writing in a research paper, first you have to protect your research paper by publishing, by applying for the patent, and after that you can publish into anywhere. So that is the important message that I want to give. So now we move into the different second intellectual property right, that is called design. It like comes like very easy, but it's not a very simple aspect. You see, there are different designs of clothes are coming to the market, and there is a design war between the different clothes company. There is a design war between different ornaments company, like those are the companies which are into the market. One company cannot copy the ornament design of another company. Why? Because that ornament design is protected under the design rights. So design rights are mainly the shape, configuration, composition of lines or colors that is applied to any article, whether in two-dimensional or three-dimensional or in both form, by any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article applied to and are judged solely by the eye. That is very important. The design rights is not linked to any technological advancement. It is only judged by the eye. Okay, that is very good design. Oh yes, that design is very good. Anywhere, if you are seeing any shoe, any cloth, and even the design of mobile, design of washing machine, design of fan, these all things are protected under the design rights. You see, these are the examples. Even the small water bottle is protected under the design rights. You see the different shape and configuration and surface pattern of bottles of the Coca-Cola from 1900 to now 2021. These are different shapes, and these all are protected. You see the bottles of Coca-Cola is different, thumbs up is different, Limca is different. Why? Because all these are protected under the design rights. That is the main, like you see the hallmark of any company. You see the design of set of articles, ornaments, shoes. What are the? This is the process of filing of design application. In the Kolkata, you can file online or offline both. The third one is called trademark. That is very also important. Okay, what is trademark? What is it? What is its importance? Trademark is mainly for the brand name. If you are buying any company of Samsung or Apple or Oppo, how can we differentiate between different mobile? Only by the brand name. Okay, this is for the Samsung mobile. This is from the Apple mobile. So they have protected their brand name. Even the KFC name, even the you see the Nike, the tick mark, it is also protected under the trademark. No any company can use that tick mark. Why? Because that is a brand value, that is a brand sign of that company. You cannot copy that. A trademark is a mark adopted for distinguishing in the course of trade the goods and services of one trade from those of other. It is mainly used for the differentiation of the different product. That product is for that company and that product is from that company. That is the importance of the trademark. What is the subject matter of trademark? You see the product mark and the service mark. Product mark, that is the product that is selling into the market, like Relaxo, Bisleri, any company that any product you are seeing into the market. And another is called service, that are providing a service. Like Make My Trip, Is My Trip, Trip Advisor, different service company, IT company like Infosys, TCS. These all names are protected under a trademark. Subject matter of trademark, certification mark. These are different certification mark, like you see the BIS hallmark, AG mark, ISI hallmark. Even you see the sound mark are also protected under the trademark. In the past, we see the sound mark of Airtel Music and Reliance Music. They are also protected under the trademark. They are shape mark. Shape mark is also come under trademark. That I have told you that comes under the design, but also comes under the shape mark, it is trademark. That shape cannot be used by a different other company because that shape is only linked with the Coca-Cola. That is a brand shape. okay, this is the shape of bottle. I can say that it is from the Coca-Cola. So you cannot fill the thumbs up or Pepsi drink into that bottle. No, it is only for a Coca-Cola because that is a brand shape mark. Subject matter of trademark. So how to indicate your trademark? If you are seeing any product, if it is named like TM, it means the application is still pending. It has not been granted. And if it's like R and circle around it, it means okay, now it is registered and that trademark is linked with that product. In this way, you can differentiate between the trademark. If you are seeing any product which is not given any symbol like this, you can understand that either that is a fake product or it has not any brand name. It is just a simple product. So now we are moving into the copyrights. So in the copyright section, we know that like if you are pick any book and first or second page, you will see it is written like it is copyright protected. What does it mean? It means that no any other person can copy that any items from that book and can start selling that book under his own name. It cannot be possible because it is copyright protected. Okay. Copyright is a right that is given by the law to creators of literature, dramatic, musical, and artistic work and producer of cinematographic films and sound recording. You see, these all things comes under copyright. Literary, dramatic, like if you're writing any drama, musical and artistic work, like if you're writing any music, if you are making any music for any song, if you are making any film or any sound recording, these all things come under the copyright. So you see, no two song has same music. We see if you are listening any music, we see that no any two song has same music. Why? Every music is copyright protected. If I am creating any music by my hard work, how can I allow someone to use my music? It cannot. It is not possible. So I can protect my music under the copyright. If you are if you are singing a song, it is copyright protected. If someone is singing your song on any stage, they or he must take first permission from you that I am going to sing a song, and after singing your song, I am commercializing it, I am earning money. Only after I allow that person, they can sing. That is the importance of copyright. So you see a singer singing a song of other singer. It is only possible if he take permission from that singer. It is not possible without any permission, and that is the importance of copyright. If you are writing a poem and and if you are thinking that it is a unique poem, it is not copied from anywhere, and I can sell this poem to any publisher and I can earn money. First, you must protect your poem under the copyright, and after that, you can publish it. That is the importance of the copyright. What is copyright? It is a bundle of right, it is automatic right, and it is exclusive right that is given to creator of original work of authorship. If any author is writing a book, he is not going into the market to sell the book. No, he write a book, he sell that book to any publisher like TMH or any publisher, and that publisher publish the book and sell into the market. How does the author earn money? He earn the commission. Like if you are selling a book and if you are earning any profit, I want 10 to 20% of your profit yearly. And in this way, an author sitting at home is earning money. If so, how does a filmmaker earn money? In the same way, he writes a film story and he sells that film story to any producer or any director, and he after that and through that he earn money. How does these all things go around? It is go around through the copyright. Why the government of India has provided a method that is called copyright, so that you can protect your literary work. So you see that dramatic work. If you are writing a drama, it is also under copyright protected. If you think that okay, now my drama is very good, and any other person can copy that drama and commercialize it. If you think that, you must first protect it under the copyright. You see the sound recording, artistic work, even art. If you're drawing any art, you see that there are a lot of arts that are sold into the market at a very high price. By saying that, okay, this art is from that artist and that art is from that artist. How do we know that art belongs to that artist? Because that artist got a copyright protected under this art. Therefore, we know that that art belongs to that artist. And if he is selling that art into the market, artist must getting some profit percentage also. See the musical work. If you are creating any music, it is also comes under the copyright protection. Cinematographic films. So there are two rights that is given by the copyright. One is called economic right. Second is called moral right. Like, I am writing in a book. Like S.C. Verma is writing in a physics book. Even after 20 years or 30 years, we all know that that book is known as S.C. Verma. That is called a moral right. A second is called economic right. He is selling the book into the market and he is earning money. So there are two rights that are given to the copyright. One is called a moral right. That book belongs to that person. That is a moral right. And he is selling the book. He is earning money. That is called economic right. So there are different term of protection that is given to the different rights of copyright. One is called the literary and dramatic and artistic and musical work. This is given for the life of author plus 60 years. Like, let's suppose any person is writing a book. So that right is given till that person is alive plus 60 years. And after that, anybody can copy from that product and start selling it to the market. Then there will be no problem. Cinematographic film and sound recording. It is given for the 60 years from the date of publication. After 60 years, it will be freely available for the public. Broadcast reproduction right. It is given for 25 years from the year following the year of broadcast. Performance right. It is given for 50 years from the year following the year in which performance is made. So type of work and author. Like for the literary or dramatic work, it is given for the author. For the music work, it is given for the music composer. For the artistic work, other than the photograph, that is given for the artist. For photograph, it is given to the person who is taking the photograph. A cinematographic film or sound recording, that is given for the producer. And literary, dramatic, musical, or artistic work, which is computer generated, is given for the person who has created. Now we will see the SICLD, Semiconductor Integrated Circuit Layout Design. We already see that when we open a mobile, any television or anything like AC, it is made up of semiconductor integrated circuit. What is the importance of SICLD? The importance of SICLD is that the size of SICLD decides the size of a product. The size of SICLD is very small, it is very compact. That mobile also come in very compact form. It not be bulky. You see, in the past, we have very bulky television. Now we are seeing into the market very slim television. How very possible? It is possible only through the compact form of semiconductor integrated circuit. In the past also, the television are made of a semiconductor. Today also, it is made of semiconductor. The only difference is that the circuit has become more and more compact, and that decide the size and shape of the product. The last one that we are going to discuss, that is called geographical indication. Till now, what we have discussed, like the patent, design, trademark, copyright, semiconductor integrated circuit, these all things are given to a particular person. But that geographical indication, the name suggests that it is linked with a geography. It is linked with the particular place. A geographical indication is an indication that identifies a product that have a specified geographical origin and possess quality or a reputation that are due to that origin. So it links with the product is linked with a place from where that product comes. It's linked with the place of origin. Therefore, we link the importance of that place also with that product. You see the Darjeeling tea. Okay, the tea comes from the Darjeeling place. But it is linked with a place called Darjeeling. So that product, if someone is selling that product into the market, that must be sold with the name of Darjeeling tea, no any other name. We want to give the importance to a place also, like Madurai Malli, Jia Kasala rice. You see the Nilgiri tea. You see the Makhana marble. Ratlami Seo, Kanchapuram silk. You see the product is linked with the geography. The product is linked with the place. And that is the importance of geographical indication. You see the Kathputhlis of Rajasthan, Kashmiri saffron, Telangana Telia Remal, Naga Mircha Madhubani painting. You see, different product is linked with a different place. We are giving importance to the place also. The Sikkim large cardamom, Telangana cereal painting, Andhra Pradesh Bogli Vina, Nagpur orange, Andhra Pradesh Tirupati Laddu. So you see, the intellectual property is everywhere. If you see around into a room also, you see the technological advancement in the mobile, television, laptop, the personal computer. These are all linked with the patent. The name of company linked with the trademark. The design of the mobile linked with the design rights. Okay, so there are books in our rooms that are linked with the copyrights. Okay, so you see the intellectual property everywhere, and it is important to protect the intellectual property. But there are different validity of different intellectual property. Intellectual property is not given for a lifetime. It is given for a limited time. Like patent. Patent is given for 20 years from the date of filing. If you are applying to the government of India today, okay, then from today to the 20 years, you get the right of your product or process. That is called patent. It is given for 10 years, and again it can be renewed for more 5 years. So maximum it is given for 15 years. Trademark is given for an indefinite time, and after every 10 years you can renew it. Therefore, you see that the name of the company is permanent. What you can renew it permanently after every 10 years. Geographical indication, it is also for a lifetime. It can also be renewed after every 10 years. Copyright is given for the lifetime of author plus 60 years for the dramatic, artistic, musical, and the published literary work. And you see, the different intellectual property rights have different validity period. Who can apply for the patent, for the design, for the trademark, for the copyright, for the SICLD? Any individual or company can apply. But for the geographical indication, it is not applied for a single person. That right is given for a particular place. Second is all IP rights in territorial in nature. All IP rights from patent, design, trademark, semiconductor level design, copyright, and the geographical indication. All are territorial in nature. If you get the right, you are getting it only in India, not outside India. So this is data of last 5 years of different types of the patent, different types of intellectual property. You see the patents in 2018-19, it was 50,000. Now it is 82,000. 22-23. In 23-24, we have crossed 1 lakh. Design it is 12,000. Now 22,000. Trademark from 3,23,000 to 4,66,000 geographical indication. From 52 to 211. Copyright from 18,000 to 30,000. Essentially from 0 to 23. You see, we have different. We have continuously increasing our intellectual property rights, and that is the main motto. That is the main aim of this awareness program, that people should be aware of their rights. The main thing, there is no any lack of talent in our country. There is many lack of awareness, and that awareness needs to be spread, so that people know that they have the right to protect their intellectual property. If you are writing a book, if you are writing a poem, if you are writing a song, you have to copyright. If you are writing a research paper which can be used for the technological advancement, you have the patent. if you are designing something that is very new, you have the design rights. Okay, if you are opening any company, you want to protect the name, you have a trademark. You see the different intellectual property and different intellectual property rights. So these are the, some important points that we must remember. First is called first protect, then publish. Means first you must protect your intellectual property, then after that you can publish into the public. Before it, you cannot publish. Second, all rights are territorial in nature. All rights are only protected in India. The registration is done by the sovereign authority. In India, it is Government of India. All rights are given for a limited period of time. It is not given for the lifetime. Trademark and geographical indication are given for lifetime, but it should be renewed after every 10 years. No automatic relief. If you are getting a patent, any other person can sue you. So there is infringement suit in the it is provided. There are renewal fees that is paid for some IPRs. Appointment of patent agent is not compulsory. You can file patent by yourself, and or you can hire a patent agent. So what are the different career opportunity in IPR? One is first is the government job. You can become the government of patent and design. Sorry, examiner of patent and design, examiner of trademark and GI, examiner of copyright. For that, there is exam held by the Government of India. Other is patent agent. You can become the patent agent, trademark agent, GRF, SRF agent, or patent litigator. These are different IPR career opportunities. So this is for today. All the basic things that are linked with the intellectual property rights have been discussed. Hope you have enjoyed that PPT today, and hope you get some information about the intellectual property rights. So thank you.
Thank you so much for this vast information regarding the patents and the copyright. And I'm sure that this will definitely be helpful for the researchers and those who are about to apply for the patent or there for copyright issues. Okay, so if we talk about intellectual property rights, it has proved itself to be invaluable in all senses in the social and economic fields and in the world. It has gained immense popularity in the recent past. It is what motivates people to create and innovate things which are governed by intellectual property laws, and these are the creation of minds. And thank you, Mr. Nikhil Ranjan, for providing such a vast information pertaining to IPR. And now I would like to request HOD of Department of Physiology, GGDST College, Chandigarh, Dr. Indu Mehta, to render vote of thanks. But before that, sorry, Pam. Yes, there are some queries in the chat box also. So I would like to, before we render the vote of thanks, I would like to mention those queries, and so that Mr. Nikhil Ranjan could answer to those queries as well. So, sir, should I ask the questions on behalf of the participants?
Actually, maximum queries has already been replied. I hope no other queries are remaining. We can ask for queries directly from participants by unmuting.
All right. And sir, there is one more query related to artificial intelligence. Like these days, it's the AI era, and now these people are also using artificial intelligence for the invention, right? So, what issue can be generated if they use artificial intelligence and take the help of artificial intelligence in addressing, or applying for the patents and other things?
Yes, if they are applying for protection of the patents for their inventions, which in which artificial intelligence has been used, okay, and if it is a process or a product, then it may be patentable. But there exists one criteria of non-patentability, which is under Section 3K of the Patents Act, which defines that computer programs or computer softwares, okay, that does not have technical advancement. Okay, so if it falls under that category, then it may not be patentable. However, if the applicant can prove the technical advancements like reduce hard disk access time, okay, effective memory compression techniques and all these things. So then that invention may be patentable.
Okay, all right. Thank you, sir. Thank you for this information. And it's really going to helpful for the participants and for us as well, who are into this applying for the patents process. And
Query has been received that can we renew patents? Please try to remember that patent is only a one-time protection. Okay, after 20 years, it comes under the public domain, and it cannot be further protected. However, the improvement of that particular invention, if it causes any technical advancement compared to the already existing product, then that improved product can be patented. So, but patent is only a one-time protection. Okay, we may proceed for the conversations.
all right. Thank you so much. Okay, so now I would like to invite the HOD of Zoology Department, Dr. Indu Mehta, to render the vote of thanks.
Thanks, Dr. Gurjeet. Well, it is my pleasant duty to propose vote of thanks. First of all, I, on the behalf of college management and college principal, would like to extend warm thanks to our today's young and vibrant students. Such a wonderful talk. So, hello, sir. Very nice explained about the types of IP, its importance, how we are going to protect it. You talked very nicely and explained in simplified manner about the patent and the copyright as well. Thanks a lot indeed. I owe a special thanks to our college management and our principal, Dr. Ajay Sharma, for their continuous help, support, and guidance. Sir is proactive, always proactive in guiding and organizing such events from time to time. Thanks a lot, sir. My humble thanks to each and every member of the organizing committee. I should say Dr. Vikram Sagar, Dr. Jyoti, and all the other members for organizing such a relevant talk today. My special thanks to our
अबे तो उस टाइम कोई था नहीं ना अब तो ये बैठ जाएगी
and Mr. Vijender Singh for their technical help. Last but not the least, I am grateful and I extend my sincere thanks to the faculty members, students, for participating and enjoying the session, and I'm sure they made the best use of this opportunity. Thanks, a big thanks to everyone. Thanks a lot. Have a nice day. God bless you all. Over to you, Dr. Gurjeet.
Thank you so much for this lovely words, ma'am, Indu ma'am, and thank you so much, Mr. Nikhil Ranjan, for such an enlightening session regarding this IPR. And I also would like to congratulate you all that it's Intellectual Property Rights Day. So enjoy. Thank you so much for your participation, everyone, and thank you so much for listening to this session.
Thank you.
Okay, so we are ending the meeting. Thank you all for your participation. Have a nice day.
Thank you, sir.